everyone, and welcome to the Hudson Institute's panel discussion on intellectual property infringement and state sovereign immunity. My name is Devlin Hartline, and I'm legal fellow at the Hudson Institute's Forum for Intellectual Property. We have three great panelists with us today to discuss this important and developing issue in IP law. States generally have sovereign immunity that prevents individuals from suing them in federal courts for either monetary damages or injunctive relief. But this sovereignty is not absolute. It can be abrogated by Congress, or it can even be willingly waived by the states themselves. Back in the 1990s, Congress passed laws purporting to abrogate state sovereign immunity for patent, trademark, and copyright infringement. This gave IP owners the ability to sue states when the states themselves are the infringers. However, the courts ultimately held that Congress invoked the wrong constitutional powers when enacting these laws. But they also left open the door for Congress to try again using the correct constitutional power. In order to successfully abrogate state sovereign immunity, Congress must first develop a record showing that state infringements are a significant problem that rises to a constitutional violation that is not remedied by the states. The U.S. Patent and Trademark Office, as well as the U.S. Copyright Office, recently conducted studies to determine the extent of state infringements, with the goal being to develop a record that Congress could again use to abrogate state sovereign immunity. These reports are now available, but it remains unclear whether they are sufficient to support abrogation and whether Congress will even try again. And to discuss these issues today, we have Kristen Osenga, the Austin E. Owen Research Scholar and Professor of Law at the University of Richmond School of Law. We have Kevin Madigan, Vice President, Legal Policy and Copyright Counsel at the Copyright Alliance in Washington, D.C. And we have Rick Allen, co-founder, executive producer, and director, Nautilus Productions. Kristen and Kevin will tell us about the legal issues surrounding abrogation, and they will discuss the studies from the Patent and Trademark Office and the Copyright Office. Rick will tell us his experience in taking his copyright claim against the state of North Carolina all the way up to the US Supreme Court. We'll start with opening remarks by each of the panelists, and then we'll have a moderated discussion diving into these issues more deeply. I'd like to thank everyone for being here with us today. And with that, I'll turn it over to Kristen.
Thanks, thanks, Devlin. As Devlin noted, what we're talking about today is whether the government can be sued for infringing somebody's intellectual property, specifically patent, trademark, or copyright. As he mentioned, I'm going to provide some background information, a little more detail about these previous laws and lawsuits, and then talk about the patent and trademark report that came out recently. And I'll let the other gentlemen talk to you about copyrights. So the short answer, if the question is, can the government be sued for IP? The answer is, it actually depends on which government. If we're talking about the federal government, the answer is yeah, sure, sue away. At least in patent law, we have section 1498, go for it. But if we're talking about states, as well as instrumentalities of the states, and in the world of patent law, at least importantly, public universities, the answer is not so much. So while the United States has specifically waived its own immunity for claims of patent infringement, and these lawsuits can generally be brought against the federal government for these claims, state sovereign immunity limits the ability to sue states or state-related instrumentalities in federal court for IP infringement. And so as Devlin mentioned, this largely comes from the 11th Amendment to the Constitution, which protects states from being sued in federal court unless Congress has clearly and unequivocally abrogated a state's immunity via statute, or if the state has waived its immunity or consented to being sued. Back in the early 1990s, Congress tried to enact statutes that barred states from asserting sovereign immunity in IP cases. Specifically, these were the Specifically, these were the Patent and Plant Variety Protection Remedy Clarification Act and the Trademark Remedy Clarification Act, relevant to what I'm talking about. In 1999, the Supreme Court invalidated both of these statutes as unconstitutional in a couple of cases that are known together as Florida prepaid. So while Congress does have the authority to abrogate state sovereign immunity in certain circumstances, the Supreme Court determined those circumstances just weren't present when the statutes were enacted. Specifically, while a state's infringement of a private entity's intellectual property rights may be an unconstitutional deprivation of property without due process under the 14th Amendment, not all infringements would satisfy this situation. And so what the Supreme Court said is a state's infringement would only violate the 14th Amendment if it were, quote, intentional or at least reckless, and that the state did not provide adequate remedies to that the state does not provide adequate remedies to redress that deprivation. So in Florida prepaid, the Supreme Court noted that when Congress enacted the two remedy clarification acts, it was not responding to a history of, quote, widespread and persistent deprivation of constitutional rights, nor were these two acts based on a lack of adequate remedies provided by the states. Therefore, the acts were deemed unconstitutional, and state sovereign immunity for lawsuits for patent and trademark infringement persisted. So more recently, after a case that I know Kevin and Rick are going to talk to you much more about, a couple of senators, specifically Senator Tillis and Leahy, requested a study from the Patent and Trademark Office to see how often patent and trademark owners face infringement by states or state entities. Basically, what they're asking is state infringement of patents and trademarks widespread and persistent, or is that infringement at least intentional or reckless, and are state remedies that are available sufficient? On the patent and trademark side, the PTO published a request for information in November of 2020. They then added some additional questions to the study in January of 2021, trying to get at how much state infringement is happening. Based on the responses to these requests, and there were only 11 comments were submitted, and then independent research performed by the Patent and Trademark Office itself, the study found that there were 78 instances of infringement of either patents or trademarks between 1985 and 2020. 49 of those cases were patent, 29 of those cases were trademark. Of course, the problem is, as is with most studies, there's significant limitations to the study, far and above the 11 answers, okay? The research that was done by the Patent Office itself, as they say in the report, is based on litigated cases. And with the availability of sovereign immunity as a defense, it's very unlikely that many of these cases come to court. So the very small number is based on those people who thought maybe they could get around sovereign immunity. So these and other limitations make these numbers, the 78 total, 49 patent, 29 trademark, not really good markers of what's really happening. So based on that data, the PTO declines to offer conclusions whether this is widespread and persistent. First of all, there's significant limitations in the data, but also, as the Patent Office report notes, that standard is incredibly vague. There is no legal meaning for the word widespread and persistent. The Supreme Court hasn't decided what those words mean, even though that's what they used in Florida prepaid. And they also declined to offer an opinion on whether the infringement by the states was intentional or reckless. The report does, though, do a pretty good job of looking at the variety of remedies that might be available, sounding in tort or in takings or what have you. And the report actually does conclude that it is unlikely that any remedy provided by state law for infringement is going to be adequate. So that second prong is met, but the Patent and Trademark Office report on patent and trademark infringement by states is not conclusive. And with that, I'm going to turn it over to Devlin.
All right, thank you, Kristen. Next, we're going to hear from Kevin about the copyright situation.
All right, thanks, Devlin, and thanks to the Hudson Institute for inviting me to be on the panel. So I'm going to start off by talking a little bit about the intersection of sovereign immunity and copyright, and then move into the recent Copyright Office study and report. And forgive me, there might be a little bit of overlap with some of the introduction that Kristen just gave. But so I'd start by saying that for most of our country's history, it was understood that state sovereign immunity did not extend to suits for infringement of intellectual property, meaning that if a state or a state entity, like for example, a state university, infringed your copyright protected work, you could sue them in federal court and hold them just as accountable you would a private person or entity. Now, even though there was this long-standing recognition that state entities should be held accountable for infringement, over the past 35 years or so, courts have revived questions surrounding state sovereign immunity to IP claims. There was this Supreme Court decision in 1985, Atascadero v. Scanlon, which held that if state sovereign immunity is to be abrogated or overridden, that Congress must use unequivocal language, which basically means that in order for a citizen to breach the shield of state sovereign immunity, Congress needed to pass a law explicitly saying that it was okay to do so. Now, as you might imagine, copyright and other IP owners were not too happy with that decision because it sort of opened the door to unchecked infringement by states. So then in 1990, in order to ensure that copyright owners had an effective remedy against infringing states, Congress passed the Copyright Remedy Clarification Act, which I'll refer to as the CRCA from now on, which abrogated sovereign immunity with regard to copyright claims. And everything was good through most of the 1990s until a couple cases that Kristen mentioned came along and sort of threw the CRCA's validity into doubt. And these cases, the Florida prepaid cases, basically held that in order to abrogate state sovereign immunity, there needs to be a sufficient record of harm, and the means adopted to prevent such harms need to be congruent and proportional to the harms. And that's something known as the congruence and proportionality test. And so even though the Supreme Court case that came to this conclusion was a patent case, it wasn't long before the CRCA was challenged and the constitutionality of the statute was sort of thrown into doubt. So in the 20 plus years since these decisions, state copyright infringement has been on the rise, which I can talk about a little more later, but litigation over the CRCA's constitutionality was pretty rare or insignificant. And that is until Allen v. Cooper made its way to the Supreme Court in 2019. And I'm not going to say too much about that now because we have Rick Allen with us to discuss his experience. But I will say that although the Supreme Court unanimously held in that case that the CRCA was invalid, Justice Kagan's opinion does say that nothing in the decision should stop Congress from passing legislation in the future that would abrogate sovereign immunity. The law just has to be narrowly tailored and supported by a sufficient record of harm. So the court, basically provides this roadmap for Congress to pass a valid law based on the powers granted to them by Section 5 of the 14th Amendment that says Congress has the power to enact laws that enforce provisions to ensure that states don't deprive any person of property without due process. And Congress paid attention to what the Supreme Court said. And as Kristen mentioned, shortly after the decision, a group of senators wrote a letter to the Copyright Office and the Patent Office requesting a study to evaluate, how much infringement is going on and whether there are adequate remedies for copyright owners under state law. And so the Copyright Office began its study in early summer 2020, I think, and they posted a notice of inquiry soliciting comments from stakeholders on a number of different questions related to the extent of the problem. And to help out the Copyright Office with its study, the Copyright Alliance, my organization, launched a public survey open to creators and copyright owners, asking them about their experiences with infringement by states. And we also conducted interviews with a number of individual creators and organizations that have encountered state infringement. And as a result of this research, we compiled what we believe is compelling evidence showing that remedies against state infringement are inadequate or really non-existent, and that state copyright infringement occurs frequently and is very harmful to copyright owners. Now, so we submitted all of that data and survey evidence as part of our comments, and along with, I think, close to about 50 other comments that were submitted. And the Copyright Office conducted its study over the course of just over a year, and it published its report on August 31st. And its conclusions are a bit of a mixed bag. There's some things that we liked, and there was others that we found more frustrating. And I'll just go over a few key takeaways that we can talk a little bit more about later. The The report found that the evidence gathered on instances of state infringement far exceed that underlying the Copyright Remedy Clarification Act. And it bases the conclusion on the survey data we submitted, as well as about 150 cases that were reviewed by students at the Arts and Entertainment Advocacy Clinic at George Mason Scalia Law School, as well as other individual anecdotal evidence submitted by copyright owners. The report also says that states' immunity from damages leaves copyright owners with inadequate remedies. And again, we can return to that later. Unfortunately, the report then goes on to say that it's unclear whether the evidence gathered in the study would be found sufficient to abrogate state immunity under Supreme Court precedent. Basically says that the threshold set by the Supreme Court since the CRCA was enacted has been set quite high, and instances of unlawful conduct must be sufficiently numerous, which sort of gets into this question about how many cases of infringement are enough, or how much harm to a copyright owner must occur to satisfy the congruence and proportionality test. But the report does conclude by saying that the Copyright Office continues to believe that infringement by states is an issue worthy of congressional action. And it references a more narrow approach than abrogation, which is known as the waiver approach, by which state entities that want to enforce their own IP rights would have to waive their sovereign immunity. So overall, the report doesn't really provide the assertive recommendation to Congress for full abrogation that we had advocated for, but they do explicitly say that there are other avenues Congress should consider. And so maybe I'll stop there for now.
All right, thanks, Kevin. And I looked through the comments that were filed at the Copyright Office, and the comments from the Copyright Alliance had the greatest detail explaining what the scope of the problem is. And I know you were instrumental in running that survey, so I just wanted to thank you for that. And last but not least, we're going to turn to Rick Allen. Rick is not a lawyer. Rick is a videographer, and he was infringed by the state of North Carolina, and he had the pleasure of going all the way to the Supreme Court and unfortunately not winning there. So he's going to tell us about what happened there.
All right. Thank you, Devlin, and thank you to the Hudson Institute. It's a pleasure to be here. And thanks, Kevin and Kristen, too, for the intro. So as Devlin said, I am the Allen and Allen v. Cooper. And I always like to start with a history lesson here to kind of lay the groundwork for kind of how this all came about.
Blackbeard probably has one of the most bloodthirsty, notorious legends or folklore associated with him than any of the other pirates. He operated in and around the Caribbean, over in the Eastern Caribbean for a number of months, and then he pretty much disappears off the radar. And a team of North Carolina underwater archaeologists is trying to find out if he lost his ship just over a mile from Beaufort Inlet, North Carolina. Blackbeard terrorized the Caribbean in the early 1700s, building his reputation as a cutthroat and a killer.
So, back in 1718, Blackbeard had just blockaded the port of Charleston with 4 ships, his flagship, the Queen Anne's Revenge, and 3 sloops, and he had about 300 pirates under his command. He then proceeded to Beaufort, North Carolina, where he ran his flagship aground in what I like to call the first case of corporate downsizing in the New World. He had 300 pirates under his command, and they hadn't been paid in a while, hadn't taken a prize. And as their historical records say, the rum had run out and the rogues were plotting. So Blackbeard needed to do the easy thing and just get rid of some pirates. So he ran his flagship, the Queen Anne's Revenge, aground, and also one of his sloops, the Adventure, and he took off in another one of his sloops, and another pirate named Stede Bonnet headed for Ocracoke in his sloops. And he effectively cut his payroll in half. So fast forward from June of 1718 to November of 1996, and a marine research firm called Intersal, which is working under permit to the state of North Carolina, found a wreck off of Beaufort Inlet, North Carolina, and fairly certain at that moment that they had found Queen Anne's Revenge. Within about a year and a half, they had signed a memorandum of agreement with the state of North Carolina, where they handed over the wreck to the state of North Carolina in exchange for the media rights, a small share of the treasure, which they knew really didn't exist because Blackbeard had plenty of time to take any quote unquote treasure off the wreck, and also some replica rights. So early 1998, Intersal had made an agreement with North Carolina Public Television to create a documentary to air on North Carolina Public TV. And I was hired as the underwater videographer on that project. So in the spring and summer of 98, while I was working on it, I took a look at the memorandum of agreement between Intersal and the state. And it was very clear to me that the intellectual property rights landed with Intersal. And so I went to Intersal and said, let's make a deal. I will document this shipwreck for you over however many years it takes. And I get to keep the rights to my footage. I'll own the copyright, but I'll pay you a 25% royalty on anything I license. And this was pretty much a win-win for everybody. Personally, it's great because as a documentary filmmaker and underwater filmmaker, this is the absolute best job you could ever have, documenting the recovery of Blackbeard shipwreck, the most infamous pirate probably in history. For the state, it's a win because they get a professional to document their work. They had no capability to do this work. They didn't have a real interest in it, and they didn't have the technology to do that. And it wasn't going to cost them a dime. And for Intersal, it was a win because they got to exercise their media rights through me and to make some money in the process. So everybody won. But as I like to say, free wasn't good enough. And as time went by, I provided footage to the North Carolina museums free of charge and for conferences and that sort of thing. And also, whenever you saw a documentary on the BBC or History Channel or National Geographic, I provided the footage for that and licensed that footage over time. So fast forward to about 2013, and Intersal got in a disagreement with the state of North Carolina over renewal of their MOA, their memorandum of agreement, and filed a complaint in the Office of Administrative Hearings. And that led to a settlement agreement. And that settlement agreement also included Nautilus, because at the same time I found out that they had been distributing some of my work commercially and to other entities without my knowledge or permission. And so as part of that settlement agreement, we entered into a piece of paperwork. And the key part of that for me was that they would return my footage unless it had a time code and a watermark on it, and that they could use it for research purposes. And you can also see under the heading of copyright violations, they agreed to pay me $15,000 for those violations. And then we had a deadline of the end of January 2014 to get that done. So almost within 24 hours of the signing of that settlement agreement, the state of North Carolina began to violate certain terms of that agreement, primarily with Intersal. And these violations continued to build and get more egregious over time. And the disagreements between the state and Intersal and Nautilus started to grow. In 2014, Intersal filed a lawsuit in state court for contract violations against the state. And then what happened next was probably what really started off the whole Allen v. Cooper process. In August of 2015, the state of North Carolina passed what I like to call, and what has come to be called, Blackbeard's Law. And Blackbeard's Law converted all of my video and images from the shipwreck into the public domain. And it specifically targeted shipwrecks, vessels, contacts, relics, artifacts, or historic materials in the custody of a state agency. And since the state of North Carolina had as much as 80 hours of my footage in its custody, this was a real problem for me. And so soon after that, in December, we filed our lawsuit in federal court over copyright violations with the state. And actually, within about 3 weeks of the state passing Blackbeard's Law, they began to repost videos that had been part of the original settlement agreement in 2013 and began to re-infringe my copyrighted work at that time. So they passed the law, began re-infringement, and then in December, we filed our lawsuit. Now, as the court cases continued, one of the interesting things that the state did in their filings with Intersal is that they claimed that their agreement with us in the 2013 settlement agreement was void, illegal, and unenforceable. And so this is part of the record at this point. And so here's a brief timeline of how this has gone. We're still in federal court right now, pursuing our lawsuit, even after our loss at the Supreme Court because we are pursuing a takings claim, saying that the state has now violated my 5th and 14th Amendment rights. And Judge Boyle, who is our federal judge in the Eastern District, has granted our motion for reconsideration. As of today, the state appealed to the judge and asked him to reconsider his motion for our motion for reconsideration, and has filed an appeal with the Fourth Circuit over that motion for reconsideration. And we have yet to actually file our amended complaint. So they have prematurely appealed a document that doesn't exist. So that pretty much brings you up to speed. Let me ask one more thing. I think one of the things that's instructive here is people ask, why did this happen? According to the North Carolina Department of Natural and Cultural Resources, a new museum, a new Blackbeard Museum in Beaufort, North Carolina, where the old museum is housed, would have a $100 million impact on the local economy. And to give you another side point, any modern traveling exhibit or exhibit of artifacts from a shipwreck is very multimedia heavy, and video would be a very important part of that. For example, in Tampa, the Titanic exhibit had 900,000 visitors over a 9-month period at $18 a head. So you can do the math on that as to what the economic value is of my footage to an exhibit or to a museum or something like that. So with that intro, I would be more than happy to answer any questions you might have and go wherever you'd like to go.
Great. Thanks for sharing your story, Rick. It's really interesting. And I think it brings something real to the table, because we're not just talking about these things hypothetically, right? And the infringement of your work, it's really egregious, especially considering you had a settlement agreement and then they did it again. And then they even tried to pass Blackbeard's law in order to convert all your property to public property. And maybe that should be called Rick Allen's law, because it seems like it was geared directly at you. But I'm happy to hear that your case is still ongoing and now you're pursuing other theories under the takings or maybe the due process clauses, which is really interesting. But your case demonstrates that this is a real problem. States are infringing IP rights, and you had to go all the way to the Supreme Court to try and see if the state sovereign immunity had been abrogated with the CRCA, and we found out that it hadn't. And so I really appreciate you doing all the hard work, because I can't imagine that was easy going all the way to the Supreme Court and then still sticking with it. And so I want to talk about, though, is what is the scope? What is the full scope of IP infringement by the states? I mean, we can list a handful of cases. Rick's is a real obvious one. Kristen talked about how they looked at cases that had been litigated in the Patent and Trademark Office report. Kevin talked about how they did a survey of people, which is probably a good way if we're going to get the numbers up there. But I'm just wondering, what else can we be doing? Because I know Congress is interested in abrogating sovereign immunity, but they have to have this record first, right? They have to support it and show that it's widespread and persistent, that these things are intentional or reckless, and there's inadequate remedies under state law. And so what else can Congress do? Can it hold hearings? Should they be doing more studies? How can we get more information to identify the scope of this problem?
I can jump in there, Devlin. So, it is tough. Like as Kristen mentioned, there's not a strong record of litigated cases because a lot of them get dismissed early on because of state sovereign immunity. Once the state enacts that immunity, they're able to make the case go away. So that's one of the reasons, we launched this survey, because we thought maybe, by reaching out to our greater membership, which includes, over 1 million individual creators, that we would hear from folks about their experiences who, may not have brought a case because they knew it would, they had no recourse because of state sovereign immunity. And, our research and survey results showed that state infringement is frequent and harmful, and does increasingly threaten the copyright system. And just to go a little deeper into some of what our survey found, I think one of the key takeaways was that we found that infringement had steadily risen starting in the mid to late 1990s, around the time of the Florida prepaid cases, and increased incrementally yearly through the 2000s and 2010s. And we had 115 respondents who responded to the survey and said they had experienced infringement by states or state entities. And that may not sound like a huge amount, but I would also note that over half of the people who responded said they had encountered multiple instances of state infringement. People talked about experiencing it dozens of times, or countless times, or infinitely many times. And so it's difficult to get exact numbers on the amount of infringement. And another thing I'll mention is that the numbers are probably more substantial than our survey captured, because most copyright owners don't have the time or resources to constantly monitor for infringement. And like I said, they're even less likely to pursue copyright infringement lawsuits when they know that meaningful remedies will be blocked by sovereign immunity. So it's challenging to get these big numbers that apparently Congress and the copyright is looking for, but at the same time, the standard's really unclear. There's no magic number. Is it 100? Is it 1,000? No one really knows. So it's sort of it puts I don't blame the Copyright Office or the PTO for sort of sidestepping the issue a little bit, because they don't know, and they say in their report that the standard is unclear as set by the Supreme Court, and so it's difficult for us to move forward with a clear recommendation for full abrogation.
Yeah, and this is a problem in constitutional law generally, right? There's a line, and the court will say, okay, which side of the line you're on. But they never tell you exactly where the line is, right? And so how many infringements are enough infringements? Well, whatever the Supreme Court says, right? Kristen, do you have any sense of what the scope of infringement is in patents and trademarks?
No. And because I think it's really hard to know. So just to explain my flippant answer, I would venture to guess that a lot, but not all, of infringements by the states is probably happening in the university setting. The Department of Public Works is less likely to be an infringing entity for a state than the state universities. And so the problem there is that a lot of it may not even be known to the university that it's happening. If it's happening in individual departments and labs, universities are oftentimes very diffuse. A lot of state universities are often very large. And so it's entirely possible that nobody really has the ability to put a finger on it. Now, I will say, just as a side note, just because you're a university doesn't mean you're not infringing because you're doing experiments and research. So there is a federal circuit case from a while back called Madigan versus Duke. Obviously, that involved a private university. But what the federal circuit said is that even if it's a university, a research university, if they are infringing another person's patent, even to do research, that's still patent infringement and is still, cause of a liability, cause of action. And so I think the real problem with getting at the scope and finding those big numbers, as Kevin mentioned, in the patent space at least, is really understanding what's happening in every department and every lab at a state university is going to be near impossible. And there's not really a good reason for universities to go around looking for infringements on their campus. So I don't know that we'll ever really know.
Yeah, well, and that's interesting. You don't know what's happening in a laboratory if somebody's practicing an invention. Maybe if they were using a trademark in commerce, it would be a little more obvious. But I do imagine that public universities, there's a lot of infringement going on. And my guess would be actually most of it is copyright infringement, not patent or trademark infringement. And so there are some cases like with, course packs for classes, you get those kind of infringement cases. And I imagine, they're showing movies and they don't have a license to do that. I'm just imagining, well, and probably a lot of students are using peer-to-peer networks to download, but, that wouldn't be the state actually infringing. Rick, did you want to chime in?
Yeah, just to piggyback on what both Kevin and Kristen said, as somebody who's been there, what's really interesting, for example, the UNC Press, which is part of the UNC system, has over 4,400 registered copyrights. And so it's confusing to people like me that the state of North Carolina can hold copyrights, can register copyrights, and can enforce those copyrights against their citizens, but we don't have that same benefit of that same law. In my case, I did the work, so I'm the creator. I registered my copyright, and I've even watermarked my work. So by law and statute, I've literally done everything I am required to do, and it's not enough. And so pretty much speaking for all the other creators out there, I don't think any of us want a different law or a special set of laws. We just want the same law, where federal copyright law applies to all of us equally. If I want to use somebody's work, I have to license it. I have to get their permission. I have to come up with some sort of agreement. And that's a pretty standard thing in any industry that involves IP. Go to the owner, get their permission. You may get it for free. It may cost you something. And if everybody did that, we wouldn't have a problem here. And so for myself and people like Michael Bynum and Jim Olive, who are fighting their fights in Texas in the state courts and soon move into federal, it's very frustrating that a constitutional right doesn't seem to exist, and that we're literally breaking new legal ground every time we file a piece of paper.
Yeah, no, and that's a very good point. Is the states can own IP rights, right? They can own patents, trademarks, copyrights. Universities own lots of IP rights, but then at the same time, it's kind of have your cake and eat it. It's like, well, we can own IP, we can sue people for violating IP. But if we violate their IP, sorry, we have sovereign immunity. You can't touch us. And so, I mean, that does seem fundamentally unfair. and that's part of the problem, right? So it seems like we do have reason to think that there is more widespread infringement, but it's being underreported for a lot of reasons. You can't just look at court cases because people aren't really bringing a lot of court cases because of sovereign immunity. And then it seems like we really are having trouble putting our finger on exactly what the extent of the infringement is. And then if you do a survey like Kevin did at the Copyright Alliance, I've heard criticisms. Well, those are just anecdotes, right? That maybe they had a fair use defense. Who knows? And so they, people try and discredit that. So it seems like it's a problem that we're having to even define the scope of infringement. But moving back to kind of what you were talking about, Rick, I have a question because, I read through most of the comments that were filed in both of the studies, and I thought it was interesting. So like on the copyright side, we had libraries arguing that, like state university or public libraries arguing that, maybe it's a good thing we have sovereign immunity so we can be in the business of loaning out works and making course packs, and doing good in society. And so sovereign immunity protects us. And then the same thing as Kristen was talking about, in the laboratories at state universities, if they don't have to worry about being sued for patent infringement, maybe that's a good thing. And so I was wondering, what's your reaction to that sovereign immunity is maybe a good thing?
No, I disagree fundamentally. I know you're shocked by that answer. Well, first off, let's talk about it. I mean, universities enter into non-disclosure agreements. They enter into patent agreements. They enter into trademark secret agreements with private entities in which intellectual property is to be protected. And there are serious legal consequences if they break those agreements. So it's kind of talking out of two sides of your mouth. Libraries also buy books. They don't get them for free, or they get them for a discount. They have agreements with the publishers to use those books. And it's an interesting thing because one of the arguments I've heard is, well, you were left, we stole your car, but we only took the tires from it. That's the analogy, right? We left you with the car, you have everything else. But the difference in IP is that when you took the tires off that car and left me the rest of the car, you then gave those 4 tires to 100,000 other people who then copied those tires to 100,000 other people. And those tires cease to have any value because everybody in the world now has a copy of those tires because they're intellectual property. They don't exist in the physical world in that regard. And so it doesn't matter that you only took the 4 tires off my car because you gave away all the rest of it. And you've destroyed that value. And so I think that's an interesting argument. And it also goes back to the same thing I said before. If you want to use my work, or any other creator's work, get permission. Like I said before, I provided my footage to the North Carolina Maritime Museums for free. I don't know what better deal there is than that. So why you need to go write a law to make it yours is just really interesting. And, laws aren't written for the people who follow them. Laws are written for the people who break them. And so when it comes to copyright infringement, there may not be a huge amount of government entities or agencies or universities that are doing it, but there needs to be some recourse for those who do. And I mean, certainly one of the reasons why we filed our lawsuit is when you have a set of facts where you have an infringement, where money was paid for that infringement, the state agreed to stop it, they then passed a law and then re-infringed. Why would you not go to court over that? Because you're not going to get a better set of facts ever in a court case.
So I'll jump in, Devlin. So a few things about that. If you read the comments that you mentioned that were submitted to the Copyright Office, a lot of the comments that are for sovereign immunity were submitted by public universities or university organizations. And a recurring argument was that, sovereign immunity shields them from being overwhelmed by a large number of meritless copyright lawsuits. But there really wasn't much, if any, evidence submitted that sort of supported that theory. And there's plenty of private universities that don't enjoy the protections of sovereign immunity that you would think if they were just inundated with meritless copyright lawsuits all the time, there'd be some sort of evidence of it, and that just really wasn't shown in the comments. And then the other argument you hear is that most of these unauthorized uses by universities or state entities qualify as fair use, and that may be the case in certain instances, but if it does qualify for fair use, then abrogating sovereign immunity would have no effect on that use. And in fact, it might actually help develop the fair use doctrine if some cases of alleged infringement that state entities claim are fair use actually played out in the courts and were not dismissed due to sovereign immunity. And then the last thing I'll say, which is getting back to something Kristen said earlier, when a lot of people think about unauthorized use of copyrighted materials in like an educational setting, they think about like research or work done in the lab, or like the situation, Devlin, you mentioned where there's like a class pack being handed out to students. And those may or may not be fair use, but we should also be very clear that as far as the use of copyrighted works, sometimes it's by university athletic departments, which can be huge money-making entities that operate more like businesses, than like a research institution. And they can use music without authorization, or in the case of Michael Bynum, they're copying his book and sending out to their boosters as a purely money-making effort. So it's not just all sort of clear fair use when it comes to university settings.
Yeah, no, and that's a good point. Those cases in Texas, Jim Olive and Mike Bynum, they're pretty egregious facts. And Rick Allen's case is pretty egregious too. And so we're seeing that these states aren't necessarily the best actors out there, right? And it's not all about, it's for education and we're trying to help students. No, a lot of it is they're just taking it because they can get away with it.
Yeah, so I'll jump in on the patent side. Patent law actually doesn't have a fair use. There is no fair use when you infringe someone's patents. And that case I mentioned earlier, the Madigan versus Duke case, says even if you're doing it for research purposes, it's still infringement. So the bar for infringement is very low, and universities don't get a free pass. There is no fair use. So I wanted to highlight a couple of the comments from the Patent and Trademark study as to why abrogating sovereign immunity would be detrimental. And I hope you hear the sarcasm in my voice there. I really don't agree with these comments at all. But I think they're worth mentioning because I think they're terribly wrong. So one of the comments that came into the Patent and Trademark Office as far as the benefits of sovereign immunity and why we should keep sovereign immunity is that with respect to these public universities, because they don't have to worry about patent infringement suits, they're getting to spend all their money on R&D. Well, no, that's not how that works. A lot of the research that's funded at major research institutes comes from government grants that have very specific things on which they can be spent. That money isn't going to be all of a sudden hauled over into the coffers to defend lawsuits, taking it away from R&D. That comment makes no sense. It just doesn't make sense. But they also, with very similar to what Kevin and Rick had mentioned, they say, and these would be nuisance suits anyway, or patent troll suits. There's very little evidence that patent trolls are seeking to go after public universities as defendants, to the extent there are patent trolls, which there are not. But if there were patent trolls, public universities would not be their #1 defendants. They're looking for cash cows. They're not looking for public universities. So I was really kind of disheartened when I saw that comment, because I thought it did the familiar trope, which happens a lot in patent law, that if you don't have a really good answer, yell patent troll. And ooh, okay. So, but the other one is also very similar and very timely to some other stuff we're seeing going on now, which is another commenter or two mentioned that sovereign immunity is good at the state level because then states can manufacture generic drugs. Whoa, buddy. That is also a really terrible idea, and not a really good reason to keep sovereign immunity as a doctrine. I'm not sure even where to go with that. States who do want to manufacture generic drugs can go through the same ANDA process the generic drug manufacturers want to go through. It's purposely designed by Congress to be much less onerous. So good, states can go through it too. Making it so that they can infringe pharmaceutical patents so that they can supply drugs to their state citizens has about as much sense as that idea of states going up to Canada to buy their drugs. It's the wrong way to solve a different problem. The problem's over here. Oh, wow, blurry hand, sorry. The problem's over here, and they are solving it by saying, oh, don't sue us. So I thought those comments were incredibly disheartening. It really kind of made me think, wow, of those 11 comments, if that's the best that came in, we really didn't get a good study from the Patent and Trademark Office. We didn't have a good survey like Kevin and the Copyright Alliance were able to pull off, so.
Yeah, I mean, I read those comments too, and it was really interesting. Like this notion that since they have sovereign immunity, they could actually get a generic into the market sooner, and so that benefits everybody. And I was like, wait, you made like 20 assumptions there that don't make any sense before you got to that point. So I wanted to revisit this idea of waiver. And so Kristen mentioned earlier that the federal government has waived sovereign immunity for copyright and patent infringement, and you can sue the federal government in the Court of Federal Claims under Section 1498 for infringement. And I think it's limited in what remedies you can get or whatever, but you can actually sue the federal government. And so how are we going to get states to waive, right? And so assuming that we can't abrogate, we can't force them, how can we persuade them to waive their own sovereign immunity? And so, I mean, one idea that I've heard floated is that, well, if they're going to own IP and actually exercise their IP rights and, sue other people for infringement, well, as soon as they sue somebody for infringement, it should be that, boom, they've just waived their own sovereign immunity, so they can't have it both ways. Do you guys have any thoughts on getting states to actually waive?
Yeah, I mean, I think it's honestly pretty simple. It's about leveling the playing field. And by that, I mean, it's subjecting states to the same exact rules that everyone else plays by. So if a state entity wants to own IP, wants to enforce that IP, and wants to be able to recover damages, then they need to waive their sovereign immunity. And that is essentially what this waiver approach is. And it's not a novel idea. 20 years ago, or just almost 20 years ago, Senator Leahy, who is the current chairman of the IP subcommittee, introduced legislation that included these waiver provisions. He was sort of a champion of trying to fix the sovereign immunity problem. And that was part of the IP Protection Restoration Act of 2003 that never passed. But these ideas have been around for a while and have been supported in bipartisan efforts. And I think now, with the Copyright Office reports express endorsement of waiver, I think a lot of people are hopeful that some folks on the Hill will take another run at it and try to pass a bill that's not as broad as full abrogation, but narrows it down a little bit to waiver. And I think the waiver is something that's harder for folks on the other side to really argue back against, because it simply levels the playing field.
I agree with Kevin that there's probably going to have to be a level playing field. Excuse me. There probably has to be a level playing field. I was kind of thinking it along the lines of a quid pro quo. If we're going to have the states give up their sovereign immunity, maybe there's something we can give them. And there is actually something, it's a little esoteric in the patent world, but stay with me here. So there's a process at the patent office to have issued patents declared invalid. It's supposed to be cheaper than litigation, faster than litigation, et cetera. They're known as post-grant proceedings. One particular one is known as IPRs, inter partes reexamination. And so interestingly, the idea of sovereign immunity doesn't exist at the patent office with respect to state entities. So in 2018, the Federal Circuit held that the St. Regis Mohawk tribe could have their patents invalidated by the Patent and Trademark Office. And state sovereign immunity is very analogous to tribal sovereign immunity. And then the Federal Circuit a few years after that, in a case called Regents of the University of Minnesota versus LSI, said sovereign immunity does not immunize state universities in these post-grant proceedings that are held at the patent office in order to have their patents invalidated. And I'm not suggesting that we impose sovereign immunity there. What I'm going to say is this. What we also know is that the Supreme Court has said federal government cannot try to invalidate somebody's patent because the statute says that it's a person. A person can bring one of these post-grant proceedings, and the Supreme Court has said a government is not a person. And so maybe what we could give states is the ability to bring these post-grant proceedings to invalidate other folks' patents, while at the same time waiving their sovereign immunity to be sued in court for infringement. So it's not quite a quid pro quo because it's probably a little smaller what we're giving them and a little bigger what we're taking away, but at least it would be something where we would be, within the same innovation ecosystem, within the same set of laws, giving and taking in a way that might prove a little more palatable than just saying, Remedies Act, you don't get to have sovereign immunity like they tried to do in the 90s.
Thanks, Kristen. That's super interesting. And so we're getting to the end of our time, and we've talked about what is the scope of the problem. Are these intentional or reckless infringements? How do we even know how many are happening? But the other side of the test is the inadequacy of remedies under state law. And so having read the reports from the Copyright Office and the Patent Office, they discuss this a bit, and every state is different, so it's hard to paint with a broad brush and say this is what's available under state law. But we do have some recent cases. I mostly follow the copyright cases here, but those cases in Texas with Jim Olive and Mike Bynum. So they've come with other theories, right? So they can't just argue copyright infringement because of sovereign immunity. And so they say, okay, it's a taking under the state constitution or the federal constitution. It's a violation of my due process rights. And so we're seeing these constitutional arguments be made. And we've had some, I would say, mixed results. So we had the Supreme Court of Texas say, well, it's not a taking for reasons that I can't explain without getting really angry. And so I'm just wondering, and I know Rick's case is still ongoing. And so he's making constitutional arguments now in his case. And I was just wondering, what are you seeing? Are remedies under state law, or are they enough? Are they inadequate? And is it a blessing if they're not, because then it means we can abrogate?
Yeah, so I sadly don't think there's a lot of hope for these alternative claims, which is, again, an argument for proponents of sovereign immunity. Like, well, they exist, these alternative remedies, like takings, but the Copyright Office report was pretty clear that they don't see these as viable alternatives. We've seen copyright owners try to bring state takings claims recently, and state courts have done everything in their power to sort of sidestep the issue or flat out reject the alternative claims. There's recent cases out of the Fifth Circuit, Devlin, you mentioned, in Texas, that have denied federal takings claims. And while they say that they've left the door open for a regulatory takings claim at the state level, I think it's really hard to imagine that they'd shift course at this point. And the problem is that these cases have shown that courts are reluctant to find that intellectual property infringement constitutes what they call a per se taking, which the court says, is sort of reserved for, a real property taking or related to the physical occupation of land and those type things. And they also talk about sort of this idea of the non-rivalrous nature of copyright or IP infringement, which, means that because a copyright owner retains some key legal rights in their bundle of rights, like Rick said, they only took the wheels of his car, but he still got the rest. They say that that's not a taking, regardless of the harm done. So again, I think it's sort of unlikely that the takings claims would fare any better under the state law scheme, which is all the more reason that Congress should consider a federal legislative fix.
Does anybody else want to chime in on that? Yeah, so it's really interesting. There's this conceptual problem. If you take somebody's physical property, that's an easy one. But what about when you're trying to square it with intellectual property? Is it a per se taking, as Kevin mentioned, or do we have to get into this regulatory taking idea? And so, personally, I think it clearly should be a per se taking, but the courts are just having trouble saying, they'll say that copyrights or patents or trademarks are property for the due process clause, but then they're unclear whether they're property for the takings clause. And to me, this doesn't make a lot of sense. And there's a lot of historical reasons to doubt that what they're saying is accurate. It seems like we understood this stuff better over 100 years ago than we do now. And so I agree, there's a lot of uphill battle that has to be done in order to get these kind of constitutional claims to go anywhere. And so I see that we're down to the very end of our time. And so I wanted to give everybody a chance if they had to chime in with any final parting thoughts. In particular, I'm just wondering, what would you tell inventors or creators who are having their works infringed? And should they be hopeful that maybe there's a light at the end of this tunnel, or shouldn't they be?
Oh, wow. I would say if you're involved with a state entity, run away. Honestly, you have no recourse right now. And I guess one way to look at it, if you take my case and just reverse it and make me the infringer and say I had done this to the state of North Carolina, what sort of situation would I be in? And I like to say I'd probably be wearing an orange jumpsuit and we wouldn't be having this discussion right now, because that's the reality of it. So as long as there's this inequity in copyright and intellectual property in a world that runs on intellectual property, we've got a big problem. And whether I break down the door or Mike Bynum or Jim Olive or somebody else, at some point the courts and the Copyright Office and Congress is going to have to come to grips with this, because it just doesn't work.
I don't think I can top what Rick said, so I'm just going to rely on Rick's answer for mine.
So I'll chime in here, and I would just say that because there's no clear standard and no sort of magic line related to the congruence and proportionality, or no magic number of instances of infringement that would automatically trigger congressional action, that I think our lawmakers need to think sort of more broadly about whether state sovereign immunity really serves the greater purpose of our copyright system or our intellectual property systems. And I would sort of argue that by giving a free pass for states to infringe while not providing copyright owners with any meaningful remedy really does not serve the purpose of our copyright system. And And then just as far as advice for, individual or small business copyright owners who are encountering state infringement, I would encourage you to get in touch with your, local congressman or congresswoman and your senators and let them know it's a problem. And also to get in touch with the Copyright Alliance, because we're always trying to build a better record of the extent of infringement and harm that's going on.
All right, all good answers, and thanks to everybody. Rick, I'm rooting for you to go back to the Supreme Court, Allen v. Cooper 2.0 on the due process or takings claims, because that would be really exciting for me anyway, watching from the cheap seats. So I wanted to thank everybody again, Rick, Kevin, and Kristen, for taking time out of your day to join us. And I want to thank everybody online who's watching this for joining us today too. I thought it was a very interesting discussion and I really enjoyed it. And with that, I want to say thank you all and enjoy the rest of your day.
Thank you.